Donald Trump, of course, as we all know, has been kicked off the ballot in the state of Colorado because the Colorado Supreme Court said he definitely engaged in an insurrection. Now, the question is, before that obviously goes to the Supreme Court, where it is likely, unfortunately, to be overturned, how does that play for Donald Trump in the other trials that he's facing? That brings me to another question. This one from YouTube community member ARMUSC757, who asks, will the fact being found that 45 participated in an insurrection by the Colorado Supreme Court be used in all the other cases against 45? Now, all the other cases, no. They're probably not going to bring it up in the New York hush money case or the documents case. And I know that's not what you're talking about. I just wanted to be funny for a moment. It is Christmas Day after all, right? Let's have some fun. But is it going to be used in Georgia? Hell yeah. Is it going to be used in front of Judge Chutkan? Yeah, 100%. Legal experts have actually been coming out over the last few days talking about the ways in which it will be used, because that is vital. And here's what's going on. Trump has tried to argue, both in Georgia and in front of Judge Chutkan as recently as just a couple days ago, that what he did was simply engage in freedom of speech. And you can't prosecute a guy for exercising his First Amendment rights. Well, the Colorado Supreme Court actually turned that on its head, because they specifically pointed out that speech is not free speech when it is in furtherance of a crime. And the crime, of course, being the insurrection, or supporting the insurrection, which is a crime. Therefore, Donald Trump's speech, whether it's saying go fight like hell or go find me the votes, if it's in furtherance of a crime, it's not protected speech. So yes, that part of that ruling is in fact going to be used both by Jack Smith and Fani Willis. Now, here's where things get a little bit complicated, because as I said, there's a good chance the Supreme Court overturns this ruling from Colorado. But overturning the ruling doesn't always necessarily undercut the arguments and the decision made by that lower court. If the Supreme Court does not specifically overturn the wording and phrasing that the Colorado Supreme Court used, it can still be used as a form of legal precedent in the other cases. So here's what I mean by that. If the Supreme Court says, hey, we actually don't think the 14th Amendment applies to people running for president of the United States. We think it only applies to Congress. Therefore, Trump cannot be disqualified from the ballot. That is the most likely case with the Supreme Court. So if all they do is say, hey, 14th Amendment just doesn't apply to him, okay, fair enough. Not really, but you know what I mean. That doesn't change the facts of the case. That doesn't change the determination of the Colorado Supreme Court. It only changes the application of the law. It doesn't change their legal arguments. It doesn't change their legal reasoning. It just says this specific law does not apply to this guy. Therefore, those arguments, the reasoning, the rationale, the decision from Colorado can still be used against him. If the Supreme Court rules that the insurrection was not an insurrection and therefore the 14th Amendment cannot apply, then it kind of gets thrown out the window. You know, you could try to make the same arguments, but if the Supreme Court rejects the arguments themselves, then you got an issue. So I hope that explains it. I know that's a little murky, but there is a world of difference between the Supreme Court saying a law doesn't apply to this person versus you interpreted things incorrectly. So as long as they go with this first one, saying just the law doesn't apply to him, all of the other arguments remain intact. Ring of Fire has fresh content 7 days a week, so if you want to be reminded about it, don't forget to subscribe to the channel, hit the little bell to be notified every time a new video goes up.